Welcome to our session on apps. I am Julie Brill. I'm a commissioner at the Federal Trade Commission, and I have the honor of chairing this session. I'm going to give some brief opening remarks about apps and about the work that the Federal Trade Commission has been doing, and then I will introduce our really terrific panel, and we'll get right into the discussion. So, does everybody here know who or what the Federal Trade Commission is? Have y'all heard of us? Okay, I'm seeing a lot of hands. So I won't go into too much detail, but I'll just say we are run by commissioners. Interestingly, I found out yesterday, this is somewhat unusual, we have 4 commissioners now, and we are all women. We also, all of the heads of our bureaus, our Bureau of Competition, Bureau of Consumer Protection, and Bureau of Economics, are also all run by women. So I'm pretty proud of that. I am one of them. And we do a lot of different things. We cover a broad swath of the economy. As I said, we do competition, we do consumer protection, and we are the U.S.'s leading privacy enforcer. We are first and foremost an enforcement agency. But ever since we were created over 100 years ago, we are also a very large research entity. We do a tremendous amount of research and policy work. So I'm going to just focus in on what we have been doing with respect to apps. We are engaged in all aspects of the app mobile ecosystem, the app system and the mobile ecosystem. Not just privacy, but we are doing a lot with respect to the collection, use, retention, and security of personal data with respect to apps as well as devices. We're also very focused on enforcing the Children's Online Privacy Protection Act, otherwise known as COPPA. And of course, as many of you know, if not everyone here knows, the General Data Protection Regulation has imported the concepts from the US with respect to children's privacy and will, in 2 years when it kicks in, require verifiable parental consent before information about children can be collected and used. And that is precisely the model that we have in the United States. So I thought I would talk a little bit about all the work that we've done with respect to COPPA. We've also done a lot of work with respect to retail mobile location tracking, which is tracking of consumers as they go through stores. Sometimes that information is aggregated so stores can learn more about what consumers are interested in looking at and where they should place their goods, and it's all completely aggregated information. But sometimes it's more personalized information to provide to consumers coupons and other offers as they're going through a store when it will be just in time and most relevant to them. We also have had a workshop on cross-device tracking, which is tracking that takes place to link one consumer to her many devices, whether it's a laptop, an iPad, and a smartphone, or whatever device she may have. It's to link all of those together, which is a much more powerful form of tracking. I wish I could tell you it was in the beginning, but it's not in the beginning. This has been going on for a little while, but it is something that is technologically very interesting, and so we had a workshop on this just a couple of months ago. But in addition to the privacy and data collection issues, we're also focused on a number of consumer protection issues relating to apps. So for instance, we have done 3 cases, well, we've completed 2 and 1 is still ongoing, regarding Amazon, Apple, and Google, sorry, Marc, who were engaged in collecting money in the context of an app. These are called in-app purchases, and we believed that there was not sufficient notice to consumers about the money that was being collected or giving them an ability to say no, especially and actually primarily with respect to kids' apps. Again, once again, focusing on kids. So at this point, we have obtained settlements from Apple and from Google. Apple, it was on the order of $32 million going back to consumers who had paid for apps when they didn't really realize, paid for the in-app purchases when they didn't really realize that was going to happen. And with respect to Google, I believe it was on the order of $19 million. We are also deeply focused on health apps, and we did a study about that. And since Finn has also done a more recent study, ours is about 2 years old, I won't go into too much detail about that. So we're doing a lot with respect to apps, and you know, I actually think I'm going to stop there because we've got a lot. We've got a great. I mean, I can go into the details if you guys want to hear. You have any questions about it? If you want to hear about our enforcement work, we not only enforce the Children's Online Privacy Protection Act, and we've brought cases against companies that were not obtaining verifiable parental consent. We brought a case against Snapchat, which had promised that its snaps or its chats, whatever you want to call them, were going to be ephemeral, but actually there was a fairly easy workaround, and the ephemerality was not real, we believed, and so we brought a case against Snapchat. We've brought cases against apps that were collecting information completely out of context, like flashlight apps that were collecting and downloading address books, you know, all the contacts of the consumer. We just thought that was completely out of context. And another thing I'll just mention really quickly, because again, this is kind of more in the consumer protection side, not so much in the privacy side, but I think it's really interesting. There are a number of apps that promise to be able to detect health conditions. So for instance, we brought a couple of cases against apps that said that they could detect whether a mole was potentially cancerous. A mole, you know, a little brown spot. Pardon me, I wish I spoke a number of languages. I'm just a complete Philistine when it comes to languages, so I don't know how to translate moles. But it claimed that you could take a picture of a spot on your skin, a mole, and you would send it, you know, it would go to the app and they would be able to tell you whether it was likely to be cancerous or not. Very little, no substantiation to this. We brought cases against several of these app providers saying that they couldn't substantiate the claims. So there's a lot of issues with respect to the mobile app ecosystem. It's not just collection and use of data, although that's a big, big issue. It's not just kids and how they're treated and how parents are treated, but it's also what they're actually saying and whether they can provide the service that they claim to be providing. Okay, with that, I think that's enough. But again, I am more than happy to answer any questions about all that we're doing at the Federal Trade Commission. But with that, let me introduce our fabulous panel. So Andrew is going, the roles that we have here are sort of elusive to me. I'm chair, whatever that means, and Andrew is moderator. And Andrew is a consultant at an ethics consultancy in London, which is known as, let's see if I get this right, Synektica? Perfect. Did I get that right? Perfect. Synektica Research and Consulting, and he's based in the UK. And then Finn Myrstad is right here on my right. He is the head of the digital services section at the Norwegian Consumer Council. Then Romain Rebera is at the end over here on my left. He is a legal officer in the Policy and Legislation Unit at the European Data Protection Supervisor. And are you based here in Brussels? Yes, and he's based in Brussels. And then we have Richard, who is right next to Romain. And Richard is a technologist at Privacy International with a focus on the area of surveillance technologies. And then last but certainly not least, we have Marc, who is sitting more or less right in the middle. And he is a Google public policy. He focuses on public policy with a particular specialty on consumer protection, and he is lead of trade issues here in Europe. So we have a fabulous panel, as you can see. And with that, I will turn it over to Finn.
Thank you very much. I'm going to just check the time, and so try to make sure that I stay brief. Thank you so much for that introduction, Julie. Thank you all for being here. I hope we have an interesting discussion. The idea is that we'll have time at the end for questions, comments. So we all promise to try to be brief, which is always a challenge when you're talking about something you are passionate about. So what I'll present to you now, I work for the Norwegian Consumer Council, and we also work with our BEUC, the European Consumer Organization, and we also cooperate with US consumer groups on all of these issues. But the Norwegian Consumer Council, we have done just recently, actually this week. Next week, we're publishing some results. You're getting a sneak preview. We have reviewed the terms and conditions and the privacy policies of 20 popular apps within the social media category, dating apps, and health and fitness apps. We've also, to couple with this, because we worked on terms and conditions for quite some years, we realized that we also need to find out what are the apps actually doing. One thing is what it says it does, and another thing is what actually happens. So we commissioned a study from a research institution called Synektica in Norway to actually go in and hack the apps and see what happens when you use the app and what happens when you don't use the app but the phone is just on. So it's quite interesting, the finds. We have found, I could say, several breaches, or what we perceive as breaches of consumer law, of privacy law, and these apps that we have found are both European apps and US apps. It's not black or white, one side is better than the other. So what I'll present to you now are some of the key findings, and hopefully you'll enjoy it. And one of the key things we see when we work with digital services in general, we worked with cloud services, we worked with lots of other types of services, we see that the key issue, and also in the US, is based on consent. And for the consent to be informed, you need to read the terms and you need to accept the terms. But what we see is that the terms themselves, if you actually manage to read them, are often what we deem in Europe to be unfair. They're one-sided, where the consumer obliges to use the service, upload his or her content, but the service itself can change the contract at his own discretion, often, without notice. And this is very problematic because that gives the consumer no chance to say, I don't agree with this. It gives the consumer no chance of potentially taking out his or her content, which is important. Data portability is a key principle in data protection. And so we don't have the market dynamics that we need for consumers to move with their feet if they're unhappy with something. This is just one example of terms we have found. But sadly, in our study of health and fitness apps, we see that all the apps actually fail to give, or at least promise to give, advance notice. Some of them give what we call reasonable notice. And with reasonable notice, we mean that they notify you by email or with a very visible pop-up combined with an email, etc. And there, 3 of the services give reasonable notice, but they don't give advance notice. So they don't give the consumer the opportunity to change or to complain or whatever. So that's a basic problem that we see with a lot of the services. Secondly, even if you do read the terms or you try to read the terms, you cannot waive basic rights with the consent. You cannot write anything you want in the contract. And sadly, what we see is that some of the services are basically saying you have no right to privacy. And this is just unacceptable morally, and it's, of course, we see this as a clear breach of the Unfair Terms Directive of the European Union. So this is unacceptable. What we also see, I mean, Julie mentioned it, they had a case against Snapchat recently, and I was glad to hear that, and I follow a lot of the work you do, and I think that's really excellent that you're going after certain apps and doing these studies. Because what we see, and I'm sure that a lot of people in this room have been exposed to these sort of licenses, where you basically give away a perpetual right, that's forever, irrevocable, you can never take it back, and it can be transferred and sub-licensed. That means that the company you give your content to can basically give it to anyone else they want to. And that is very problematic when we're talking about user-generated content, such as a profile picture. And this is the Tinder user terms. That's a dating app, and it's generally supposed to be a service that is time limited. When you found your match, you might stop wanting to stop using the service, and you don't want to see your profile pictures appearing everywhere 5 years, 10 years, 20 years later after you're using the service. But with these terms, Tinder can do that. That's very problematic, and we see a lot of services doing this. So we did a little experiment with Norwegian Consumer Council just before Christmas, where we actually offered profile pictures for sale on the main street of Oslo to see what people reacted, how they reacted when we confronted them with the practicality of these terms. All the pictures that you see on this are fully consented to by the people involved. And all the people you see in the video are real people and nothing is staged. Let's see if we can...
også?
Det er kjæresten min.
Er det kjæresten din?
Ja, få tak i oss.
Unnskyld, er dere interessert i å kjøpe et bilde? Private pictures? Funnet på...
Etter min smak var de litt for privat.
Jeg lurer på om jeg har solgt et bilde av deg til en fyr. Have you used the app?
Kan det bare ta bildet som jeg sender da?
Det hadde vært greit hvis jeg hadde hatt et bilde av dere. Og solgt det videre. Alle krysser jo av på den der at de har lest den der vilkårgreia.
Ja, det har jeg gjort.
Vi har voksne, vi har barn, vi har i alle aldre private bilder. But did you know that you give away the rights to your pictures?
No.
But you clicked like the terms and conditions.
That's right.
Yeah.
And
Did you read it?
I don't think anybody reads that.
No.
På nakenbilder.
Hæ? Nei, ja, det er det. Det går mye av det.
Det er i sommer når de har vært og badet i,
Ja.
så har de tatt en sånn selfie.
Hvis jeg plutselig skulle sett ungen min da for eksempel på et bilde her, det er jo faktisk ikke greit.
Jeg synes jo det er helt urimelige vilkår hvis de har den muligheten til at de bare kan selge bilder som folk tar og legger ut.
So thank you so much. So that's I thank you. That's I think hopefully a portrayal of how people feel when confronted with these terms. This video is now available on YouTube, so you can share it if you want to. It would be great actually if you do. So this is one of the problems. So wide licenses is a huge problem. And then we looked at one other topic that I want to share with you today, and that's basically sharing with third parties. So even if the app tells you that it's not going to share, not do anything bad with your data, we do see that they have very wide clauses. And what we find with a lot of the apps, sadly, is that personal data is shared with undefined third parties. We don't know who they are, which again breaches with the basic principle that people should know where their data is and be able to access it and possibly delete it. None of the app providers specify which third parties they're sharing with, which we think is too bad. And data is shared with apps that are not in use. And I want to show you a very short animation based on a 48-hour test of the 20 apps when the phone was laying still. We didn't use it. We didn't use any of the apps. And this is what happened. Let's see. This is the data flows of the 20 apps. Data was shared, and these are the amounts of requests. I mean, this is location data. This is just pop-ups, push. Some of them are completely legitimate. But you see data is being transferred all the time from apps that should not necessarily have any function except when you use the app. So this is a huge challenge that we see with apps. There's a lot of leakage. And finally, just to finish, we also see that a lot of apps, when you stop using the app, data is not deleted. And this is another problem that we see. People might delete the app, but they might not delete their user account. They think they've deleted their user account, and there's no time limit in the terms of, let's say, after 5 years of inactivity, we delete the data. And you see a lot of them fail to do that. And that's a big problem, especially with health data and fitness data such as this. So these are just some of the results we will publish in the next few weeks. I hope you stay tuned. And I'm looking forward to discussing how we can make both platforms give users more control, how we can have app providers build in more control and maybe be a little less greedy. Because there are good apps out there. There are really good apps out there. So I don't understand why some are better than others. And yeah, so I look forward to the debate. Thank you very much.
Okay, so I hope my microphone is working. So thank you, Finn, for your talk. Our next speaker will be Romain, but I know that
I can take your slides up if you want.
Okay, but while you're doing that, I know Julie just wanted to make a quick point.
So just to follow up on the health apps issue, again, if you go to our website, ftc.gov, you'll find, and you just type in apps in the search bar, you'll find a lot of work that we've done. But on this mobile health apps issue, in 2014, we had held a whole workshop. We called it User-Generated Health Information. And we had a whole bunch of speakers talking about this issue. We also did a small study. I believe it was a little smaller than yours. You had 20 apps or so. We did 12 apps and 2 wearables. We found that collectively they were transmitting information to 76 third parties. This information included device identifiers, consumer-specific identifiers, workout routine, diet info, and symptom searches. So if you were searching for certain symptoms, that information was being not only collected but shared with third parties. We've done a lot of other studies, but I think one of probably the most important things that we've done in this space is we've created an Office of Technology and Research, which has technologists. We have them on staff. They're the ones conducting these studies, and they're working hand in glove, as we say, or side by side with our line attorneys and our economists to help us develop cases and to figure out the folks that we should be proceeding forward with enforcement actions. So, just thought I'd mention
Thank
that.
you, Julie. So our next speaker will be Romain from the EDPS.
Thank you very much, and good morning. I will try to use my application to limit my period of talking, I think. And talking about application, I think it's very interesting to see in the audience that a lot of people are taking pictures with the application. I just remind you that under the new GDPR, you might be fined by 4% of your annual turnover, even your personal one. You won't be fined if you can find the mistake in the next slides. The one who just find it may not be fined if you just see the last line. I just worked too late, I think, yesterday night, and I just made a mistake in the last line. You will see. It's not the main subject of this discussion, of course. To continue on the what was said by Commissioner Brill, the Belgian Privacy Commission, where I was working 2 years ago, took part in a sweep day in 2014, as far as I remember, which was conducted by the GPEN. The GPEN is the Global Privacy Enforcement Network. I think the GPEN reunites more than 40 privacy enforcement authorities in the world. This sweep day 2 years ago was focused on the mobile application and tried to identify some concerns that the consumer and the citizen could find when using the mobile application. And the 4 main concerns were obviously the one that were already mentioned before: the lack of transparency, the lack of free and informed consent, the poor security measures, and the purpose limitation principle, and not the purpose limitation, of course. I would try to giving example of this sweep day with a global results that was published on the website of the different enforcement authorities in the world, such as the Canadian Authority. I think this table is from the Canadian Privacy Authority, which has published global results of the sweep day. We noticed in terms of permission that was asked by the application that you were using, that the top information that was requested by the application was, of course, the localization, the location data, which is one of the most required data of the application. And another one, which is not surprising, is, of course, the access to the device identification, which is the unique identification number of your mobile application. You can see that, for example, a lot of application accessed the contacts, 9%, which might be surprising when you just see the purpose of the application that you are using. And you can also see that a lot of application also access the contacts of your mobile application. This survey was conducted out of, I think, more than 1,600 application, and I think a lot of areas of the mobile application has been covered, such health data, banking application, of course, public transportation application, and betting application, of course, game application as well. For the next slide, I think we will see more results. You will see that the first indicator that was swept by the privacy authorities concerned the pre-installation privacy communication. We discovered that only 59% of the application swept revealed and communicated about the way that the data would be communicated and used by the mobile application provider. So it means that more than 40% of the mobile application developers did not communicate any privacy policy on the way they would use the data and the information collected by the application. Another indicator very interesting was that the user, so it's not in legal terms, but the user, the sweeper as we call it, working for the Data Protection Authority, felt that an excessive permission based on the functionality of the mobile application was asked in 31% of the cases. That means that, for example, you have a torch application asking you to access your contact data, data or your camera, for example. There is no connection between the purpose of the application, which is to give light, and accessing your contact application and your photo, for example. Another indication that was swept was the tailoring of the information, because I think it's also very interesting to see in the video that we just seen that nobody reads the terms and conditions, because obviously they are usually too long and they are not accessible for the user. So we just paid attention to the efforts made by the developers to try to make the information fit into, for example, a small screen for the smartphone. And we discovered that only 43% of the application, 33% of the communication did not fit this small screen, for example. And other results in the sweep day, it's next slide, were that in general terms, you will see that only 15% of the application swept had a result of free, which was an appropriate privacy information, clearly explaining how the application collected, used, or disclosed the personal information, which means that 85% of the other application did not provide for sufficient information about the use of the data, or information clearly explaining how the data were collected and used by the application. So I think we can go to the next slide, I think. This is, for example, a graph made by the CNIL, the French Data Protection Authority, on the 128 applications that were swept in France, and the results were quite similar to the global results that I just presented to you. I will go now to another, do you have a lot of time? To I think, document that might be interesting to make a reference to in this context. The first one is the opinion of the Working Party 29, number 2 of the 3 years ago now, on the application and smart device, and the EDPS opinion of mobile health application of last year. Focusing on the first document, I would like just try to stress to focus on one of the concern, which is the information of the the consent of the consumer. The first thing is that we see a lack of transparency, and as it was noted in the EDPS opinion, we just saw that 65% of the top 150 applications in the world only provided a privacy policy. That means that a little bit less than 40% of the application in the world do not provide a privacy policy and does not inform you about the way they're gonna use or collect the information about you. We can also see that it's very difficult to understand the way that your information is gonna be collected, because the language and the term that I used might be very vague. For example, we saw a lot of time in the privacy terms and condition, the way the description of the use of the data for market research, which doesn't mean anything to me. I don't know what's market research, or the typical to enhance the user experience. What is enhance my user experience? It's not very clear, so we can ask ourselves whether they just meet the purpose limitation principle under the directive. Another thing that we saw in the sweep application, okay, 2 minutes, is that a lot of time there was no relation between the application and the use of the application and the information accessed by the application, of course. So there is no link between the two of them. Another thing that I would like to say is that, and just to finish maybe, it's that we saw a lot of times that the acceptation of the installation of the application on your mobile phone was also the acceptance by the user to the privacy policy. So there was no distinction between the OK button to install the application and the consenting to the data protection application. I really think that when we talk about, and I would just wanted to be provocative on this last note, is that when we're talking about informed consent, the ones with a legal background will know that in civil law, a contract is only legal when you have a price and an object and a consent. But when you don't have a price, how can you pretend that the consent was fully informed if you don't know how much the data that you are handing over to the provider is valued by the provider? How can you pretend to have an informed consent and a fully informed consent? If I don't know the value of the data that I handling to the provider, how can I consider that the consent that I'm just giving is fully informed? Under the GDPR, we might have had a solution if the text was closer to the original version. That was that when you give a consent to a contract, you have to have two separate consents. Now the text of the GDPR is a little bit more restrictive than this, but we can see that the new regulation will ask you to provide a consent for the terms and conditions and also a separate consent for the privacy. I think that the solution might have been, and I will just finish on it, that we could have also obliged in the regulation any provider of an application, of course, or any other controller to provide an application totally privacy compliant, for example, for free, and another application, totally privacy compliant, against value, against the price, and another version of the application when you would be, the use of the application would be free. And then in these circumstances, we could have seen the price of the value that the provider would have asked you, but it is not provided in the regulation right now. So it's just a provocative question that I'm just asking. Are we sure that you can say that the consent is fully informed if you don't know the value of the data that you are just sending to the provider? And I think it would be a good basis for discussion later. Thank you. I hope I'm not over the limit. Okay, that's fine. My application is working.
Thank you, Romain. Our next speaker is going to be Richard from Privacy International.
I think that's a great point you just made, and I wonder if there is no renegotiation essentially in terms of the price. If there's no renegotiation of the price, I wonder, is the contract actually valid? Is that the essence of what you're saying, that when the terms and conditions change or when the app collects new data, there is no contract because you didn't know what value it was when the app changed essentially the amount of value that it was extracting from the user?
No, I just want, there's two different things. I think one thing is to say that could you have an informed consent if you don't have any value, if you don't know the value and the price of the data that you're just transferring over. But of course, if the terms and conditions change and you're not aware of it, that will be a breach of the privacy terms and conditions without consideration of the price or the value anyway. So if there is an extra additional use of your data that was not provided in the initial terms and conditions, that for sure will be a violation of the privacy law.
Cool. I see. So I did the presentation in OpenOffice, and I see it's not transferring quite well to Microsoft Office or whatever is used there. I guess, so at PI we've been looking at this notion of data, and rather than looking at the data that's expressly collected, looking at the inferences that can be made on data that actually is collected. So some of the areas that we've been looking at is identification, and I think Julie mentioned this earlier on about cross-device tracking and pattern of life analysis, so that noticing those patterns across devices can be used to fingerprint or watermark you. Other things that we've seen is when analytics can be used to take raw data, which seems quite innocuous, and convert it into various different attributes like age, sex, sexuality, those kind of things. And one of the reasons for using this stuff, if we just go on to the next slide, is that many of the inferences that can be made about you and your data may not have the protection of law when you expressly provide personally identifiable information, or under data protection law, sensitive personal information. So if, for example, raw data that you provide can then be converted into, for example, health information and religious information, you potentially don't have the same kind of protections under data protection law. So, for example, we usually give two just crude examples where your music library, I'm fairly certain most people's music library is relatively unique. So somebody who says, or an app that says, hey, I'm just informing the server of what songs you have on your device. In reality, that's actually quite a unique fingerprint of you. And the same thing if you look at your iPhone and you go into settings, location data, it will continuously figure out where your most frequented locations are. And typically those are your work and your home, or the local pub, depending on what you, whether you like to go to the local pub or not. And those are a pretty unique fingerprint of you, whether you're on an iPhone or a laptop or anything else. So we get this kind of fallacy from governments in relation to metadata that is just who called whom and when. But then you've got Michael Hayden saying that we kill people based on metadata. So the notion that this information is somehow benign or not intrusive, I think is completely false. It also gives companies who operate on this basis deniability in respect of when they may infer information about sex, age, sexuality, and that informs the decision making in respect of your access to services or what information you get provided. And of course that is highly discriminatory in most countries, that those kind of bits of information should not be used in that way. If we move on to the next slide, it didn't translate over, but each one of these, this is essentially the fingerprint of your device, and various different components of that fingerprint can be aggregated on relatively or supposedly innocuous information, such as how inaccurate your clock is, what your MAC address is, just things like how often it polls information. And I think many companies have now tried to get around the cookie directive by asking your phone or your laptop to try and render certain images, and then they measure the time it takes to do that. And very often that's a fairly unique fingerprint of your device. So they don't actually need to store the cookie on your machine to be able to track you. If we move on to the... So again, this is another one that didn't translate over, but the various different components of your fingerprints will allow disambiguation between users. So, for example, various different patterns of operation of your apps on your device can be quite uniquely identifying. And without actually knowing who you are, and without actually, or whatever that means, whether that's knowing your name, but they can actually disambiguate you from somebody else without ever you telling them who you are. And oftentimes this is a lot more accurate, because you can lie to a company and say you're somebody you're not, but your devices and the information that they surrender can betray you in terms of the ability to identify you, and over time can be quite reliable. And if we move on, then not only are the fingerprints in relation to who you are and disambiguating you from others, or in fact actually confirming that you are the same person across devices, attributes that you exhibit have fingerprints as well. So those fingerprints can be computed or inferred based on patterns. So for example, mood, if you're typing very, very fast, or if you're doing various different things. And very often these attributes are not expressly thought up by the companies, but rather the algorithms are given this information, and they learn what behavior equals certain attributes, so that when you exhibit that behavior with very, very crude data that seems very, very innocuous, very innocent, they can then get a lot of information about you. And if we just move on to the next slide, each one of those fingerprints can then be attached. The connection between that fingerprint and your tag, price tag, or whether you're happy, sad, male, female, those kind of things. And then if we move on again, I'll try and speed up. The connections between fingerprints, very often they don't necessarily need to know exactly who you are, but rather that one fingerprint is talking to another fingerprint. Later on, they might actually collapse the relationship down to figure out exactly which finger or who you are, if they need to, for various advertising purposes. And of course, if we move on to the next one, when they're attaching attributes, you can't see it there, unfortunately, but if one fingerprint has a collection of attributes and you're quite similar to that fingerprint, and you're missing one of those attributes, the service can infer, well, hey, 99% of the people who have the same attributes as you also have this attribute. They can just apply it to you. And the interesting thing with this is that it actually doesn't matter whether it's accurate or not, because all that matters is this can have quite negative consequences for people in the real world, whether or not the properties or the attributes are actually reflective of you. So if we move on to the next slide, we can we can see the various different components of this, which is tracking you vertically over time and your life events, but also horizontally who you're most similar to in various different social contexts. And finally, we have to ask the question of, well, who is to blame in respect of apps, algorithms who use information either directly or indirectly? We can't query the algorithm and say, hey, did you use age, sex, sexuality, those kind of things in your computation of who should gain access to services, because very often the companies who employ these algorithms simply don't know. And one of the options we have is simply to pollute our records. But of course, as we'll see in the next couple of slides, that can have pretty negative consequences. Again, this, unfortunately, Open Office obviously didn't carry over to Microsoft. I guess we have to have words with either Microsoft or Open Office. But the notion of a data cone is that the information is constantly growing. When you send a text message, there's this cascade of megabytes of information around the world, constantly producing metadata, constantly producing other data. And this gives rise to the slide here. Unfortunately, some of the clip art, again, didn't come out. But on the bottom left, we're essentially the population, where all our information has been hoovered up into a abstract representation of us, which we call a mirror. And so that rather than actually going to you individually to try and figure out who or what you are, services such as law enforcement, medical care, even education, will just query that proxy representation of you rather than actually going and trying to find out who or what you are, kind of like your credit score. And that can have very real consequences in terms of where you can travel to, access to loans, what contracts you can complete, and education. So many of these things are very real for people, and the amount of information that we're generating, the next few slides are pretty simple. It's just going through the catalog of information that we're now surrendering in terms of digestible sensors going into your body, your washing machine having communication, how frequently you do perform a wash, what time you perform a wash is very, very indicative of who you are, and the whole Smart Cities initiative. Just to finish on, I'll skip over this slide, but that's just that it's not all doom and gloom, because we've only had this technology for relatively recently, and it took a while before people started wearing seatbelts and engaging in safety features when the car was invented. But the next few slides are about not just what apps can do, but the hardware that we've got. So we got access to the documents that purportedly contain the Snowden material that GCHQ destroyed, and they were very, very interested in going after things like the power controller, the keyboard, and your mouse, which ordinarily wouldn't necessarily ascribe as potentially containing much information, but GCHQ obviously knew that they could extract it, so they needed to get rid of it. And various different things like the USB sticks, what they did to it. And we're now in a situation where if we want to get rid of our data, even if the companies claim that they delete it, are they doing what GCHQ does to devices, which is turn them into 2mm size dust? Or are they simply pressing the delete key, and is that sufficient? So I think I'm out of time. A little bit, 1 minute over. Okay.
Okay, thanks, Richard. And if you had to skip any of your points, maybe we can pick them up in questions later. Okay, so our final speaker on the panel today will be Marc from Google.
Thank you very much. So, Richard, a lot of food for thought there. I'm going to take us back a little bit to what the app economy is today and how we look at that. So, for us, the app economy is new. It's obviously a growing market. It's an evolving market, and it's a market for everyone. Before I give you a little bit more details on that, let me start by stating the obvious for us, which is on the next slide, and that is user first. If there are a couple of things that we know that are true, the first thing is focus on the user and the rest will follow. And I think this is a very important principle to keep in mind, and a very important principle that we keep in mind when we talk about consumer protection and apps. So let me go to the growing market, which is on the next slide. Just some figures to give you an idea of where we are today. These are pulled from several reports that I'm sure many of you are familiar with. The first one is a report produced for the European Commission, which said that European app developers did quite well in 2013, earned around 17.5 billion, and the estimation is that this will grow to 63 billion in 2018. So pretty steep growth curve. Today, in Europe and Norway and Switzerland combined, according to the PPI Institute, which is a DC-based institute, there are 1.6 million app economy jobs. I think it's interesting to know that European game developers generated over 35% of their revenues outside of the EU. So this is definitely a global market. And finally, and I think this is quite telling as well, is that the majority of mobile game players do not actually make in-app purchases in their games. So looking at these impressive figures, it's, I think, important to know that only a minority of gamers make these purchases. So Flynn, maybe the next slide. So we think, and we look at the app economy as something that's constantly evolving, which sometimes leads to discussions and improvements that are made along the way. I think that the first App Store development started only in 2007 when the first iPhone was introduced. And if we look at our users today and the developers and people that use Google Play, for instance, we don't see widespread dissatisfaction amongst the users. People generally seem to like the products that they use and the apps that they play. A report by ISFI, done by Deloitte, said that only fewer than 5% of consumer support queries relate to billing and payments. And then what we do see, as this is an evolving market, is that users want more control. And I think the way users change, we change with them. And let me please explain you by giving you two examples, which is Android Marshmallow and the conversations that we had over the past 2 years with the Consumer Protection Cooperation Network and the European Commission, which I was involved in, and which is one of the reasons why I'm speaking to you today. So Android 6 Marshmallow, this was announced at Google I/O in May 2015, so we gave the developers heads up, and we already explained to them how they could prepare their apps for the newest version of Android when it would go live in October of last year as well. Maybe the next slide, because one of the, we believe, key improvements in this version of Android is that it has redesigned the permission system. So we've done a couple of things, and I'm going to walk you through it very quickly, and if you have more detailed questions, we can talk about that later. But I think one of the main aspects is that we've simplified the permission groupings. So they are pretty easy, understandable for the average user. The icons are in the picture on the left. Something that has changed is that a permission, a prompt, will only be presented to you when it is relevant and at the moment you want to use it. So let's say, and you will see it on the next slide, if you want to make a call using your Hangout app, you will be prompted with a question: do you allow this app to access your contact details so you can actually make a call? Maybe Flynn, if you can go one slide back. I think this is something that is a very good improvement, and I think this is the slide most on the right, the picture most on the right, which is an overview. So it's an overview based on apps, and it's an overview based on permissions. So if you want to go back and see, okay, which apps have which permissions, you can actually go back and you can toggle them on and off. So yeah, now the next slide, which shows you what happens, how you're presented with this little screen. If you deny the first time, it's not a problem. If you deny it the second time, it's neither a problem, and you can even choose to prevent that box from ever coming up again. On the next slide, you will see more details of these overviews. So you can look per app, and you can look per permission. So this is the first example of how we evolve with the market and how we listen to what both consumers and our public authority conversation partners tell us. The second example is something very recent as well, which deals with a conversation we had with the Consumer Protection Cooperation Network and with the European Commission. They came to us in December 2013 with basically 4 major concerns, and I will run you through them briefly. But already in July of 2014, we were on good track of offering solutions for these problems and actually implementing them as well. So what did we change? There were concerns about apps being advertised as free, while they actually included the opportunity to make in-app purchases. So what we advised, or what we suggested to do, was not to advertise apps as free anymore if they include these in-app purchases. So you won't find a free category anymore if there are in-app purchases in there. Another concern related to children as well, as Commissioner Brill also mentioned. So we made it very clear to developers that if you offer apps that might appeal to children, it's important that they don't include direct exhortations. So what is a direct exhortation? Let's say Mickey Mouse pops up on your game asking, buy more flowers for Minnie Mouse, otherwise I will cry. That would be a direct exhortation that is not acceptable under the UCPD. I'm making this up. A payments arrangement, which is, I think, something very useful. Previously, if you would make a payment, you would give your password and you would have a 30-minute window to make purchases. This sometimes led to bills that parents weren't really expecting. So now the default setting is different. If you want to make a purchase in an app, you have to give your password each and every single time. For some of the more frequent gamers amongst you, we also heard that some of our users don't really like that if they have to hand in their passwords, let's say 20 times, because they make a lot of purchases. And then finally, the developer contact information, which is pretty clear, sometimes also tricky. If it's a bigger app developer, we're happy to provide the user with, let's say, email address or a phone number, but if it's a small developer, let's say one person in a basement, this might be a problem. Finn, maybe the second to last slide. So the app economy, as we look at it, is for everyone. It's open, and what we like to do with our Play store is that we connect users to the apps that they want. And for us, it's very clear that we are responsible for our own set of rules, which are in the developer agreements, but also in our developer guidelines. And we will make sure that those are complied with as much as possible. On the other hand, we also think that there is a very clear responsibility for the developer itself. And I think this is where the conversations with the CPC and with the EC are very interesting, is that, sometimes it might be very convenient to ask us to review a whole range of apps, but in many cases it's not the most effective way, because apps might be offered on different app stores as well. So we think that responsibilities to some extent should also be with the developer. And then finally, education. This is something that we did last year. The picture on the left is an example of a campaign that we did with the Altro Consumo organization in Italy, where we did a huge public campaign pointing people to how you can better control your settings when you use Google services. We even have this in print. There's a nice booth somewhere at the coffee tables where you can learn how you can change your account settings, for instance, in a new dashboard environment. No presentation can be finished without a CAC picture. Thank you very much.
Okay, so thank you to all of our speakers. We're going to have a question round now. As the moderator, I'm going to jump in very rudely and ask the first question myself, but otherwise just put your hand up. If you're at the back, it's quite dark and I can't really see, so you might have to wave your arms a bit. So let me just put a very simple question to all of the members of the panel. But we've seen this question of putting price on data, personal data. Romain, you were mentioning that in the context of gaining genuinely informed consent. So I'd just like maybe all of you to pass comment on the issue of how that might be possible, how to match up data with price, and whether, given the links between personal data and identity and fundamental rights, whether that even makes sense to put a price on those things.
Yeah, you want me to start? Well, very briefly, I think the price on data is a very sort of very interesting notion, and we've discussed it a lot. We're not concluded. The only challenge, the idea would be great if it worked in practice. If you can make a system that works, I think that would be the biggest challenge. The second challenge is, can you really put a price on a fundamental right? And that is like a larger question, which I think is more fundamental, which I haven't landed, but I wish. Yeah, for some transactions it would be great if we could, there would be a price on the data, but for some transactions you can't, I think.
I'll just jump in on this issue. I think one of the problems is developers often don't know the value. They launch an app, they're going to try to market the data in some fashion, and so they don't know right away. So that's going to be one issue: is how do they communicate to consumers in a changing value? I think that'll be hard. But I think much more importantly, what I would like to do, and I think that we need to do generally, is to focus on responsibility of the developers to ensure rights. Now, whether it's a fundamental right or a consumer right, I don't want to get into that argument right now, but one of the things that we are spending a lot of time on at the Federal Trade Commission is ensuring that, to the extent that data is being used in precisely the way that Richard outlined, and he went through in a very helpful way device fingerprinting. There's also beacons. There's other technology that's used. He used one example which was very helpful. But if that data is being used in a way, and Richard ended with this, that's going to harm consumers, and I'm not now talking about government surveillance. That's a huge issue. We can talk about that, or others can talk about that. But from a consumer's perspective, if that data is going to be used to raise their insurance rates, or to deny them insurance, or to raise their credit rate, that is how much they have to pay for a loan, or to deny them credit, or if they don't get a job, or they don't get a promotion, or they don't get housing because of this information. In the United States, that consumer has rights, and one of the things that we are doing is trying to communicate to the app community through our enforcement actions and through our policy work, that they will then fall under the Fair Credit Reporting Act. And what that means is those consumers need to be given an adverse action notice. They have to be given a notice that they have been harmed in those categories, those substantive categories, so that they can go and they can say, well, what data do you have about me? I want to see it, and I want to be able to correct it. And I've recently learned that in Europe, adverse action notices don't exist. The Fair Credit Reporting Act doesn't exist. So I know that there's a lot of discussion about how well or poorly we do privacy in the United States, but one thing I want to leave you with is where there is legislation in the United States for sensitive information, and credit reporting information is this kind of information, What we've done in the United States is we have protected consumers in a very significant and serious way. Another issue is debt. If debt collectors or other debt brokers have information about debt, it has to disappear from your credit report. That again, this reporting about consumers, whether they're creditworthy or not, has to disappear in 7 or 10 years. So I'll leave it at that. But I think it's very important to, we're focused on all the technology and how information is being collected. Really critical to focus in on use and how do we protect consumers in that use context. And that's something that I hope we can focus in on.
Well, just following up on on the question of data with value, I'm not sure we're at a stage yet where the data that we surrender, either intentionally or through betrayal of us by our devices or apps, necessarily even needs to be quantified. I mean, just even this notion that in UK law, a contract requires offer acceptance and consideration, which is the value, but even teasing this out and having the consumer be aware that the service isn't for free, that the service, that the price for the service is you and your personal information, I think is certainly a step in the right direction without necessarily needing to go the extra step and quantifying it, but just having that, and there's that old saying of if you don't know who the consumer is or if you're getting something for free, then you're the product of the service. I know I've messed up that quote, but that notion that we're moving to a situation where both consumers and regulators are seeing the value in data and requiring users to be made aware that that is the price of using so-called free apps, devices, or services.
Nothing to add, no.
Yeah, maybe two things. Borrowing a line that people use in the trade world that I work in a little bit is that people say, data is the lifeblood or the oil of our economy. And I think that discussions that we have focus more on data as something more optimistic, let's say sunlight, not something that's very scarce or something that's to be used only once. And I think this is an interesting way of looking at quantifying data, which is difficult, I believe. And to a large extent, the value is not inherent, but it's in the, let's say, learnings and the analysis that you perform on that data as such. And then on how this relates to the apps, I think what we believe is that providing the user or the consumer with extra control, and not like you have one-off choice, but control throughout the usage of an app is I think extremely useful, and it also shows that users are increasingly reflective on what kind of data they allow an app to use or what kind of data they allow an app to collect. And I think the more granular those tools are, I think the more trust and more confidence users will see when they use certain apps.
Just picking up on that one point, I'm just curious as to whether, I'm obviously a technologist, so I don't really care what an app says it does. I want to play with it and figure out how to screw with it. And I'm just curious in respect to the permissions, say, that Google or Apple provide, how many different ways have you guys found to circumvent your permissions to gain access to the information without going through the regular channels of the permissions?
I can't answer that question. Okay. I don't know.
Well, we brought a case against Google for them going around the Apple permissions. It was, the Google. So we've done that with. It was called our Google Safari case, and we received a $22.5 million payment in that matter.
Okay, so now I think we can go around for some questions. There's a few hands up, so we'll take a few questions in one go. So we've got a question over here to begin with. Thank you.
Hi. Does it work? Yeah. I'm Sharon Nass from the Dutch Data Protection Authority, and I have a question for Google, because as a supervisory authority like the Norwegian Consumer Council, we go after individual apps while you are one of the big containers of apps in the Play Store. And I was wondering if you're able to enforce in the App Store that app developers mention their name. Why don't you consider enforcing that they have a privacy policy, at least to start with? And while I'm really happy to see that Google sort of follows track iOS's example of offering a little bit more granular control for users whether to consent to certain permissions, one of the huge problems also described by our Norwegian colleagues is when does an app collect data? Because it's a one-off. You just say, yes, you may have my location data, but is that limited to just while you use the app, or does the app continuously collect the data? And I see a huge responsibility for the app platforms there to enforce that. Thank you.
Okay, we'll gather another couple of questions. There's a gentleman down here, and then this gentleman at the back. And you.
Hi, my name is Jürgen Bench. I work for ISFE, Interactive Software Federation. We represent European video game industry in Brussels. My question goes out to the Norwegian Consumer Council. Has there been any follow-up on the results of your study? It would be very interesting to know exactly why these companies perform these breaches. Are these companies free riders? You mentioned some big names there. I cannot imagine that they really deliberately would go against the law. It would be very interested to know what their motivations are.
Gentleman in the back.
Yeah, one more question at the back there, and then we'll have some answers. And then we've got two over here.
Thank you. I'm Claude Castelluccia from INRIA. I was part of one of the studies with the CNIL. So it was more common. I think it's very nice to have studies that show that data leaks out of smartphones. It's very nice to write recommendations and opinions, but I think we need more than that, right? Most of the app developers, they're not lawyers. They don't know how to write privacy policies. So I think it's not, I mean, as you say, it's their responsibility, but we should try to help them, maybe by providing them tools, or maybe by just modifying the old paradigm. The other thing is that you mentioned several times that users do not read the privacy policies. And I never read, right? Because it doesn't make sense to read the privacy policy. Once again, what do we do next? I mean, it's nice to show those results, but what do we do next? Can we think of better solution to protect the user beside these consent-based things and beside these privacy policies?
Okay, thanks. So we'll take some answers now from the panel. I'll ask you all to be very, very brief if possible, and then we can get the final questions from over here. So, Marc?
Okay, thank you very much for your question. You know, Android is an open platform, and I think by today there are over 1 million applications available through our App Store, and I think that creates huge benefits for both the developers as for the users. So I think that's, let's say, our starting point. And looking at that nature of the store, for us, it's clear that if an app for Android is not made by Google, we don't have the responsibility or the design, we don't have the responsibility for the enforcement of the third party's conduct. It's impossible for us, but we do have a very clear requirements in our developer guidelines and in our developer agreements, which is that users should be provided with conspicuous notice and with safeguards when it comes to the collection of privacy. And if we are notified, and I think a dialogue that we've had with both the Norwegian Consumer Authority and with the Dutch and with the Danes shows that if there is a notification and there is a clear breach of our own guidelines and of our own developer agreements, we will definitely take action. But in order for us to, let's say, monitor or design or better responsibility for every single privacy policy of an app that is available on the Google App Store, we don't think that is the right framework for how the app economy currently is structured.
very quick answers, please.
So can I just want to jump in on the tools for users and then back to this question about privacy policies. Tools for developers. Great question. We spend a lot of time doing that. We have on our website, and we also go around to the app community to describe to them just how to begin, like how do they do a privacy policy, how they should be providing information to consumers, and also the theory that they need to, if they're going to collect information, it needs to be in context. They can't start downloading, address books and contact lists if they're just providing a flashlight, things like that. And we talk about our cases that have gotten other developers in trouble for exactly those things. One of our primary concerns, though, is also security and how app developers, especially those that are dealing with sensitive financial information, need to focus on security. And so not only do we have information available on our website, but we're actually going out to the app developing community. We did our first event was in Silicon Valley, our second one was in Austin, and our third one is now going to be in Seattle. This is sort of US based, but we are a US agency. So it's a program called Starts with Security, and we're trying to tell them sort of the things that they need to know to improve security. So you should take a look at that. Finally, I want to let people know about the ad blocking wars. I mean, consumers can take this issue into their own hands, and there are a lot of ad blocking tools that are out there that the ad tech industry is now very worried about. And so publishers and the ad tech industry are now sort of trying to defeat the ad blocking tools that consumers are using. So you've got this nuclear arms race going on between consumers who are using ad blocking tools and the industry, which is trying to force them to get around it. Huge issue for the ad tech industry. I go around to the ad tech industry and say, you've got to respect consumers' rights. You got to understand that if you're going to try to get around their ad blocking tools, they're just going to develop new tools. And so much better to respect consumers' choices rather than try to get around it. Last thing on this privacy policy, the reason why privacy policies now appear on the platforms, it's not required, but at least there's a space for it, is because the California AG entered into a consent order or into an agreement with Apple and Google that requires them to at least provide a space for privacy policies.
Okay, very quickly. Anybody else?
Okay, just to answer to your question, I think actually few of the apps we read, they don't even read their own privacy policies. They've had someone do it when they made the app, so I think they're going to be quite shocked when we expose them the way we will do in a few weeks. And a few others, they are actually doing completely contrary to what they write in their policies. We found one app to be published very soon who is sending very personal data to a third-party tracking company in the US, which is not a part of Safe Harbor. And they say on their privacy policy, we will not share data with any third party. So that app will have some sweaty weeks in the weeks to come, because that is, of course, completely unacceptable. So I think there's some apps don't know. They're just focused on service, and others are doing things they shouldn't be doing. And on the question on what should we do, I think the work that Google is doing with more user control is a good way to start, but we cannot leave this up to consumers alone. They are also financial experts. They have to be nutrition experts. They have to be clothes expert. They have to pick up the kids in the kindergarten. So the debate has to be about what can the business do to clean up their act. I think the industry associations need to do much more than they're doing today. They're providing some opt-out services, but they're not opt-out from tracking. They're opt-out from targeted advertising, which is a completely different thing. So I think here they need to really pick up their act so that we can regain trust in the digital environment. I think enforcement is really important. And here, DPAs in Europe, you have an opportunity as of 2nd of February to start also going after safe harbor companies from the US. So I think that work with Julie, and let's have more enforcement. Thank you.
Okay. Thanks. Thank you to all of our speakers. Thank you to you for coming and for your questions. And enjoy the next panel.